Welcome back to America's Fractured Politics. The most recent terms of the Supreme Court have done something remarkable, and not in a good way. They have shown in real time that Edmund Burke was right. The way to destroy a constitutional order is not with a single violent act, but with a steady, relentless erosion of norms, institutions, and public trust. We are watching a 6-3 conservative majority do exactly that. Over a few short years, this court has trampled on individual rights, especially women's reproductive freedom, blown a hole in sensible gun regulation, given convicted felons and future Trumps legal escape hatches, and stripped federal agencies of the power to interpret and enforce the laws Congress actually passes. With cases like Dobbs, the court wiped nearly 50 years of constitutional protection for abortion rights, declaring that the Constitution offers no such safeguard and handing the issue back to the states, where bans snapped into place overnight. In Loper Bright, it then swung a wrecking ball through administrative law, overlooking the Chevron doctrine and telling judges they no longer owe any deference to expert agencies when statutes are ambiguous. In Garland versus Cargill, it even struck down the federal ban on bump stocks, effectively legalizing a device that turns a semi-automatic rifle into the functional equivalent of a machine gun in many states. This is not neutral umpiring. This is a political revolution from the bench, and it has been decades in the making. Much of this hyper-aggressive shift dates to Donald Trump's 3 appointments, but the groundwork was laid long before he rode down that escalator. For years, conservative legal activists and their allies in the Republican Party have worked to transform the court from a constitutional referee into a partisan power center. What we are living through now is the payoff. Think of what the court has done in the last couple of decades. In Bush v. Gore, it stopped to recount and effectively handed the presidency to the Republican candidate. In Citizens United, it equated money with speech and unleashed a flood of corporate and dark money into politics. In Shelby County, it gutted the Voting Rights Act and opened the door to a wave of voter suppression laws. And with Dobbs, it yanked away a core bodily autonomy right that generations of women had come to rely on. These are not minor adjustments. They are tectonic shifts that align again and again and again with Republican interests. The pattern is too inconsistent to ignore. So how did the court end up so confident in its power that it feels free to reshape the country over the heads of voters and their elected representatives? The intellectual vehicle has been originalism, textualism, strict construction, pick your label. The idea is simple and deceptively clean. Judges must interpret the Constitution and statutes according to their original public meaning, or the plain text is understood at the time of adoption. To some, that sounds like a way to limit judicial discretion. In practice, it has done the opposite. The late Justice Antonin Scalia was the high priest of this approach. He liked to say, gleefully, that the Constitution is not a living document. It is dead, dead, dead. According to this view, if a right isn't spelled out clearly in the text, or deeply rooted in 18th or 19th century history and tradition, courts should not protect it. That is the language the Dobbs majority used to strip away abortion rights. They emphasized that abortion is not mentioned in the Constitution and argued that the history of regulation showed no deeply rooted right. But the same logic could put an entire constellation of modern rights on the chopping block. Contraception, same-sex intimacy, same-sex marriage, even certain aspects of privacy and bodily autonomy. The irony is that the Constitution was drafted with open-ended phrases precisely because the framers understood they could not foresee the future. Due process of law, equal protection, unreasonable searches and seizures. These are not technical formulas. They are principles. They only make sense when applied by judges willing to interpret them in light of changing social realities. Originalism pretends to constrain judges, but what it really does is give them a toolkit for cherry-picking history and selectively narrowing rights they don't like, while expanding ones they do. It is worth pausing on how hollow originalism becomes when confronted with modern life. We have no idea what Madison would have thought about AR-15s equipped with bump stocks, yet the court is willing to let a device that allows near automatic fire slide back into legality, because in its view, the statute's wording doesn't quite cover it. We can only guess how the framers would have felt about billionaires pouring unlimited money into super PACs, or corporations asserting religious rights to deny health coverage. But somehow the court can find plenty of original meaning to bless those outcomes. The truth is that the real Constitution is more than a string of 18th century phrases. It is a set of ideals: liberty, equality, democracy, the rule of law. It was meant to grow, not to freeze. Judges were supposed to be wise interpreters, not political actors hiding behind dusty quotations. That is why the Ninth Amendment exists. It explicitly acknowledges that the people hold rights beyond those specifically enumerated in the text. Yet under the Alito, Gorsuch, Kavanaugh, Barrett approach, rights like same-sex marriage or a woman's right to choose are treated as historical curiosities, revocable at will. Then there's the question of power, specifically the court's power to invalidate acts of Congress and actions of the executive. That power, judicial review, is not actually written into the Constitution. It was proclaimed by Chief Justice John Marshall in Marbury v. Madison back in 1803. Ever since, the court has effectively claimed for itself the last word on what the Constitution means. There is an argument that judicial review is necessary to prevent the tyranny of the majority, to make sure transient majorities don't trample minority rights. Sometimes it has worked that way. Brown v. Board of Education is a classic example. But in this era, judicial review has been weaponized as a tool of minority rule. A six-justice conservative bloc now uses it to strike down laws supported by majorities, shield wealthy interests, and entrench partisan advantage. When the court overturned Chevron deference and Loper-Bright, it wasn't protecting liberty in the abstract. It was recentralizing power in courts sympathetic to corporate challenges and hostile to regulation. The truly dangerous part is that there is no appeal from these decisions. Once the Supreme Court rules, the only options are amending the Constitution, a political Everest, or waiting for some future court to reverse course. Meanwhile, lives are affected immediately. When Dobbs came down, abortion bans and severe restrictions went into effect in state after state, affecting millions of women almost overnight. When Garland v. Cargill struck down the bump stock ban and instantly made these devices legal again in many states that had relied on the federal rule. When Chevron fell, regulated industries gained a powerful new weapon to attack health, environmental, workplace, and consumer protections. Chief Justice Roberts likes to insist that there are no Bush judges, no Obama judges, just neutral arbiters in robes. That myth vanished a long time ago. Look at the pattern of outcomes. Campaign finance, the court sides with big donors and corporations. Voting rights, it narrows protections, blesses gerrymanders, and weakens oversight. Gun regulation, it elevates the Second Amendment above public safety. Reproductive rights, it protects the rights of states and religious objectors over the autonomy of women. You don't need a conspiracy theory when the docket and the votes tell the story. The court has become a third political house of government, and it's overwhelmingly aligned with the Republican Party and the interests of the wealthy and well-connected. Part of the reason this has been possible is that the justices themselves increasingly see politics as their battlefield. Take Neil Gorsuch. Before joining the court, he didn't just have conservative legal views. He went out of his way to denounce what he called liberals in lawsuits, accusing progressives of being addicted to the courts to advantage their social agenda. Yet on the bench, he shows no hesitation about using judicial power aggressively to reshape law and policy, particularly by attacking federal agencies and casting doubt on their expertise. Then Brett Kavanaugh, a man whose career has been steeped in Republican politics, from his work with Ken Starr's investigation of Bill Clinton to his service in the George W. Bush White House. During his confirmation hearings, when confronted with serious allegations of sexual assault, he responded not like a jurist, but like a partisan warrior, railing against the left in a televised display of grievance. That performance, for anyone else, would have been disqualifying. For him, it became almost a loyalty oath to the movement that pushed his nomination through. Add Amy Coney Barrett, rushed through by a Republican Senate days after a presidential election. in direct contradiction to the supposed principle invoked to block Merrick Garland 4 years earlier. Coney Barrett's confirmation locked in the 6-3 majority that has since delivered ruling after ruling in line with conservative priorities. Once Gorsuch, Kavanaugh, and Barrett were in place, the court's behavior changed. It started granting review in cases involving hot-button issues like abortion, guns, gerrymandering, and presidential power, precisely because it now had the votes to remake the law. That wasn't an accident. That was a majority flexing its political muscles. The structure that allows this is fundamentally broken. Lifetime tenure invites stagnation, hubris, and a lack of accountability. Justices can sit for 30 or 40 years shaping generations of law, regardless of how out of step they become with the country. And unlike members of Congress or presidents, they never face voters. Meanwhile, ethical rules that bind every other federal judge do not meaningfully bind the Supreme Court. We have watched as reports surfaced about Justices Thomas and Alito accepting lavish gifts, luxury travel, and favors from wealthy donors and ideological benefactors. There is no serious mechanism to investigate or sanction this behavior, and the justices themselves decide whether to recuse from cases involving their benefactors. Imagine any other branch of government operating on that honor system and calling it accountability. If a court this unaccountable keeps issuing rulings this out of step with broad public values, something will eventually give. One plausible scenario is that a future Democratic administration or Congress will simply decide to ignore a decision they view as illegitimate, say a ruling striking down a major voting rights law or upholding a radical attack on birthright citizenship. Another is that red states, emboldened by this court, will start defying rulings they don't like, when and if the court ever swings the other way. Once that line is crossed, the authority of the court itself begins to crumble. And that would not just be a crisis for the justices, it would be a constitutional crisis for the entire system. So what does reform look like? It has to start with recognizing that the court's current configuration and power are not carved in stone. The Constitution doesn't require 9 justices. Congress decided that number, and Congress can change it. At various points in history, the court has had as few as 6 and as many as 10 members. There is nothing sacred about 9. Expanding the court to 13 justices, aligned with the 13 federal circuits, is one plausible approach. It would dilute the power of the current bloc without abolishing the institution. Term limits are another critical piece. A 10 or 12-year non-renewable term with seats opening at regular intervals would lower the stakes of each appointment and ensure a steady infusion of new perspectives. Polls show that a large majority of Americans favor ending life tenure for Supreme Court justices. Keeping it in place at this point is a direct defiance of public sentiment. Ethics reform is non-negotiable. The court needs an enforceable code of conduct and an independent body to administer it. Recusal decisions should not be left to the honor system. Live-streamed arguments and real-time access to the court's work would increase transparency and over time help the public better understand what the justices are doing in their name. Right now, too much of the court's business happens behind a curtain, with the public left to read opinions after the fact, like royal decrees. Speaking of curtains, there is another disturbing development that has to be confronted: the so-called shadow docket. The court has always had an emergency docket for quick rulings on time-sensitive matters. But in recent years, it has used that docket to make sweeping decisions with minimal explanation. Late-night orders that reshape entire state laws, where national policies now arrive without full briefing or oral argument, and often with only a paragraph or two of reasoning. That is not how a court respectful of its role behaves. It's how a political body behaves when it wants maximum impact with minimal scrutiny, whether it is letting a controversial law take effect or blocking lower court rulings. The shadow docket has become a tool for stealth policymaking. That must be curbed through internal norms, public pressure, and, if necessary, congressional action to set clearer procedural requirements. The deeper question, though, is whether the court should have such sweeping power of judicial review at all. Marshall's move in Marbury may have been a clever institution building in 1803, but 2 centuries later it has yielded an institution that can, and often does, override the democratic will in ways that entrench minority rule. Ending or sharply limiting judicial review would be a radical change, but at this point, continuing unbridled judicial supremacy is also radical. It just feels familiar. Short of formally abolishing judicial review, Congress can and should explore ways to cabin it. That might mean jurisdiction stripping statutes in certain areas, supermajority requirements for striking down federal laws, or procedural reforms that force the court to be far more transparent and deliberate when invalidating the work of the elected branches. Any of those would be controversial, but they would at least reassert that the court is part of a constitutional system, not above it. There is also the nomination and confirmation process, which has devolved into an elaborate kabuki of evasion and bad faith. Nominees arrive thoroughly coached not to say anything meaningful about their views on abortion, voting rights, gun regulation, campaign finance, or executive power. They recite bromides about respecting precedent, only to turn around and vote to overturn landmark decisions, like Roe, as Gorsuch, Kavanaugh, and Barrett Jones did in Dobbs. One reform would be to force genuine disclosure. Senators should demand clear answers about how nominees view major precedents and how they would have decided key past cases. If nominees refuse, that itself should be grounds to vote no. The stakes are too high to accept candidates who cloak their ideology behind a fog of platitudes and then spend the next 3 decades remaking the law in secret alignment with a partisan agenda. Lurking behind all of this is the Federalist Society, a legal network that has spent decades building a pipeline of conservative judges. Leonard Leo and his allies curated Trump's Supreme Court shortlist. They groomed Gorsuch, Kavanaugh, Barrett, and many lower court judges as well. Their project has been astonishingly successful. They understood something Democrats often ignored. Control the courts, and you can win policy fights even when you lose elections. There's no magic wand to remove the Federalist Society's influence. The only real antidote is for progressives and small d Democrats to build their own robust legal infrastructure, to win elections, and to make judicial nominations a top-tier political priority. That means talking openly about the court on the campaign trail, not shying away from the issue for fear of seeming radical. Ultimately, the court's crisis of legitimacy is a democratic crisis. When 9 people, 6 really, can decide the fate of reproductive rights, environmental protections, worker safety, gun laws, and the very structure of the administrative state, democracy starts to look like theater. Elections continue, ballots are counted, but the real power resides in a body that never has to ask the public for permission. At some point, the public will respond. Trust is already at historic lows. After Dobbs, after the fall of Chevron, after decisions like Garland v. Cargill that put dangerous hardware back into civilian hands, more and more Americans see a court that serves ideology and wealth, not justice. The risk is that this distrust metastasizes into disengagement or into a generalized belief that the law itself is just an instrument of power. Once that happens, it is very hard to restore faith. The path forward is not glamorous, and it isn't quick. It requires something unfashionable. Sustained, boring, relentless democratic work. Electing leaders who are willing to talk about court reform, to expand the court if necessary, to impose term limits and ethics rules, to revisit judicial review. Pushing the Senate to treat nominations as a political battle as they are, not as exercises in polite theater. Supporting candidates who will legislate boldly in ways that make it harder for courts to pretend ambiguity where none exists. Most of all, it requires voters to stop treating the court as a distant, untouchable oracle and start seeing it as what it is, a political institution that responds, eventually, to political pressure. That pressure starts with the ballot. It starts with refusing to accept minority rule dressed up in judicial robes. The Supreme Court has lived off its mystique for more than 2 centuries. The velvet curtain, the solemn oaths, the black robes, the marble columns, they all project permanence, and authority. But no institution is permanent if it loses public consent. The question now is whether our democracy can hold out long enough for political will to catch up to the danger, whether voters will connect the dots between their daily lives, between abortion bans, deregulated industries, flooded political campaigns, guns on the street, and the decisions of this court. Whether they will decide that enough is enough and act accordingly. Because the answer to this crisis, like so many others, is ultimately the same. Get our heads out of the sand and go vote in overwhelming numbers for a government that reflects the majority's interests and values, not just those of a narrow, entrenched majority. If we want a court that protects democracy instead of undermining it, we will have to build the political power to demand it. This has been America's Fractured Politics. Please keep up the fight. If you like this episode, please like it, subscribe, share it with your friends, and comment. Thank you again.